Whether you're involved in a divorce case or a custody battle, you might find yourself in a situation where you might need to rush into court on an emergency basis to ensure the safety and well-being of your kids. If that's the case, this video is for you, where we're going to dive into what an emergency court order is, how to go about it, and how to increase your success rate. Hi, I'm Sina Mohajer with Mohajer Law Firm. We specialize in family law, civil litigation, criminal defense, and personal injury. In these mini-series, I like to dive and attack these complex issues and try to simplify it for our viewers in order to help you in success with your case or just to answer your simple questions. So if you're new to this channel, welcome. Hit that like button and don't forget to subscribe so you're always in the know-how of when new videos are being posted. And without further ado, I welcome you all to A Walk in the Park. So what is an emergency court order? Naturally, if you ever are requesting any type of order from a court, you file what's called a request for order, file it with the court, and you get a hearing date about 2 or 3 months down the road. But not every situation will warrant or allow you to have the patience and wait that long because we got the immediate need to protect these kids. In that type of situation, you can always file what's called an emergency custody order or an ex parte. In those situations, you have to be able to establish to the court that there is an immediate danger, not only to the kids, but to their well-being, or perhaps it could be an immediate danger to something else. But that urgency level is very important to establish, otherwise your ex parte or your emergency order is going to be denied. So what do you need to do in order to take the first step? First step for any emergency order is always notice. Notice is so important in anything you do in litigation, period. But in this situation, it's crucial because if you don't give proper notice, then your request is going to be outright denied, regardless if you can meet all the other requirements that a need is there and these kids are in immediate danger. If you don't give proper notice, the court doesn't have jurisdiction to do anything. So in order to give proper notice, you have to do it either by phone, email, text. You have to let the other party know that you're moving forward to court the very next day. And that's the beauty of these emergency hearings. You don't schedule it 2 or 3 months down the road. When you file it, the next day the court will review it. Normally in LA County, there's not going to be a hearing where you actually have to appear for it. These documents are going to be reviewed in chambers by the judge alone with no appearance by anybody else. So it's important that your documents are very specific and to the point. If for whatever reason your documents are convoluted or confusing and it doesn't allow the court the proper means to grant your request, they're going to have to deny it. Now, if the court denies it or grants it, 9 out of 10 times they're going to schedule it for a regular hearing. And that regular hearing is usually going to be about 21 days out. So it's not again going to be 2 months down the road, but it's going to be pretty soon. At that hearing, the court's going to want to hear from the other side. And it also gives you an opportunity to provide more information to the court. At that hearing, the court can rule either for you or against you. So it's important how to prepare yourself for that hearing. It's important to also gather your evidence. If you see any type of immediate danger to the children, for example, you find out the opposing parent, the co-parent of yours has a drinking problem or a drug habit, and they've been having visitation with the kids while being under the influence. It's important to gather this information as evidence to support your request to perhaps ask for monitored visits or some other means in order to ensure the safety and well-being of those kids. If you're defending against an emergency hearing, you're going to be notified that their other side is going to go to court the next day. And part of that notice, you have to be told what is the basis for the emergency hearing. For example, stop all visitations due to mothers or fathers' drinking habits. It's going to give you some inclination as to what the purpose of the hearing is for, so it allows you to file a response. I can't emphasize enough how important it is during this emergency stage for the respondent, the other person responding, to actually file their paperwork. Because like I said earlier, there is not going to be a court hearing at this emergency state. It's only going to be the judge reviewing paperwork in chambers. So if there's no response, there's only one side story that I'm going to be looking at as a judge to determine if temporary emergency order should be granted until we can get the parties into court. But if you file a response, it's going to give me a side of both sides, all right? I'm going to be able to review what one parent says versus the other to be able to establish whether an emergency order is warranted or it can just wait until the 21 days out when we schedule the hearing date. So if you have questions about your case, I welcome you to contact our office to schedule a consultation. I'm happy to sit down with you one-on-one to discuss your case in more detail. And if you're new to this channel, welcome. Don't forget to hit that like button and also don't forget to subscribe so you're always informed of any new videos being posted. and I welcome you all to a walk in the park.